Hello everyone and welcome to the next seminar in the Te Puna Haumaru seminar series. It's my absolute pleasure today to introduce Dr. Katherine McLachlan. Katherine has extensive experience working in the criminal justice system in roles related to policing, child protection, youth justice and victims of crime. And she's currently the teaching program director and senior lecturer in criminology at Flinders University in Australia. And she's been a member of the parole board over there in South Australia since 2015. So today, Katherine's going to talk to us about trauma-informed criminal justice. And I don't know about the rest of you, but I'm really looking forward to hearing about it. So thank you, Katherine.
Thank you very much. Kia ora and manina pudni. I'd like to welcome you here today in the language of the Kaurna people on whose land I am today here in South Australia. And I'd like to acknowledge the ongoing relationships that living Kaurna people have with the earth, skies and waters of the Adelaide Plains. I'd also like to acknowledge the mana whenua of the Waikato today. And I want to apologise in advance for my Māori accent because it's pretty rubbish, but I'll do my best with some Māori words throughout the presentation. So I started my criminal justice career in South Australia with South Australia Police back in 2001. But it wasn't until 2014 that I heard this idea or this concept of trauma-informed practice being mentioned. And at that stage, I was working for a victim support service and they were very like, we work in a trauma-informed way, but not necessarily able to articulate what that actually meant in specific terms in terms of how they worked with victims of crime. Soon after that, in 2015, I was appointed to the Parole Board of South Australia here. And I've interviewed victims of crime, but I've also interviewed many people who have offended, probably in the thousands, and really learnt of their childhood backgrounds, their life stories, and the fact that trauma and adversity kept coming up in the lives of the people who had offended as we spoke to them in the interviews. So I then completed my PhD in 2021, and that focused particularly on trauma-informed sentencing. And I'll refer to that a little bit in the presentation today, but I know that many of the people in the audience are more interested than just sentencing. So we'll talk about criminal justice and trauma-informed practice within the criminal justice system more broadly, including policing and corrections as well. Today, I'm planning on providing you with a very brief snapshot of trauma-informed criminal justice, and hopefully I'll compel you to think about the value of taking a trauma-informed approach in criminal justice practices. The presentation is going to cover a fair few concepts because I kind of need to explain what I mean by trauma, trauma-informed, all these different things before we can kind of get into what it might look like in the criminal justice system. But bear with me, I'm going to try and make it as interesting, as engaging as possible. And I'm going to be using some stories and some examples to demonstrate and support my argument that I think trauma-informed criminal justice is the way forward. Okay, so first of all, what do I mean when I talk about trauma? Trauma has got a lot of different meanings. Obviously, it means something different to, say, an orthopedic surgeon than it might to a psychologist, for example. And often in academic work, there's a slippage between whether trauma is the event, the experience, or the impact of the event or experience. So what I tend to do is rather than refer to an event or experience as trauma per se, I talk about that as forms of adversity. And that's because exposure to adversity doesn't always result in trauma. So in my mind, and using the words of Phil Wilmot and Jones from 2022, trauma is a biopsychosocial response to external events that is mediated by personal meanings of those events. Or in really simple terms, trauma is understood to mean the impact of adversity, so that is potentially traumatic events and experiences, on an individual's functioning and well-being. And you can see here on the slide that it can impact on an individual's functioning in a number of different areas. So we can be talking about traumatic impacts from adversity in terms of physiological or neurological impacts, social or relational impacts, physical, behavioural, cognitive, educational, emotional and psychological. And we'll talk about some of those examples of trauma in more detail in the presentation. Okay, so for people who are justice involved, or more specifically for people who have offended, there's two types of trauma that tend to be very common: developmental trauma and intergenerational trauma. And both of these are the result of compounded adversity. Past adversity that occurred in childhood or previous familial generations can impact the social and emotional well-being of individuals today. So developmental trauma refers to the negative impacts of chronic adversity in childhood on an individual's social and emotional well-being. Developmental trauma may present as neuropsychological trauma, changes to attachment, poor emotional regulation, impacting on a person's well-being and behaviour. And involvement in the child protection system can be a risk factor for then involvement in the youth justice system and beyond that into the adult justice system as well. We know from longitudinal studies that multiple adverse childhood experiences, and these are kind of fall into two categories. One's around household dysfunction, so there might be domestic abuse, familial mental health issues, familial drug and alcohol issues, absence of a parent or incarceration of a parent, and then also the presence of child abuse and neglect in a child's life. So those kinds of things together we refer to as adverse childhood experiences, and we know that when a child's experienced multiple adverse childhood experiences, the resulting developmental trauma is prevalent in the lives of people who offend and is a predictor of both youth and adult offending. So if we talk then about intergenerational trauma, that refers to the trauma experienced by children and descendants of those who have directly experienced the adversity. So it can include, for example, parental incarceration, which we know is a risk factor for children's future criminal behaviour. But more often, intergenerational trauma refers to First Nations people's experiences, as well as the direct experiences of adversity that can compound that intergenerational trauma. So trauma from colonisation continues to impact Australian Aboriginal peoples after years of being denied access to their languages, laws, traditions, cultures, lands and sacred places and ways of life. And I'm sure this is no news to people in New Zealand either. This compounded trauma helps to better understand that it's trauma and not culture that is predictive of the overrepresentation of First Nations peoples in the criminal justice system. Aboriginal and Torres Strait Islander people represent 3% of the Australian population, but 32% of people in prison. And as noted by Thalia Anthony, Aboriginal Australians and Torres Strait Islanders are the most incarcerated people in the world. But similarly, in Aotearoa, New Zealand, Māori people represent about 17% of the general population, but more than half of the prison population. So this idea of intergenerational trauma should be familiar to you in the ways that you work, as it is in Australia. So if we talk then about the relationship between trauma and crime and trauma in the criminal justice system, trauma is relevant for people who work in the criminal justice system for three sort of key reasons. Firstly, evidence shows trauma is prevalent in the lives of both children and adults who are justice involved or who have offended, and we'll talk a fair amount in the presentation about that. But trauma is also relevant for victims of crime. Victims of crime are sometimes, but not always, traumatised due to their experiences of crime and also due to their experiences with the criminal justice system. And practitioners themselves can experience trauma from exposure to the devastating, relentless, and often cruel impacts of crime. So fundamentally, I guess the message that I'm trying to convey here is the criminal justice system is inherently traumatic. If we talk a little bit more around people who have offended and the relationship between trauma and criminal behaviour, trauma is associated with crime. Trauma diagnoses such as post-traumatic stress disorder are associated with crime, and it may be predictive of impulsive behaviour, aggression and affect dysregulation. PTSD is prevalent in prison populations, particularly in women prisoner populations. Neurophysiological trauma can lead to impulsive, unpredictable or violent behaviour due to changes in the volume and functioning in areas of the brain associated with emotional regulation and problem solving. And we know that trauma can be counteracted by protective factors such as support from family or social networks, employment and education, personal resilience, external supports, including therapeutic counselling. However, while trauma-focused therapeutic support may help promote recovery, effective models can be difficult to access in the community and are rarely accessible in custody. Trauma is also perceived to be a risk factor for crime, and you will have noticed some of those protective factors are closely linked to criminogenic risk factors. So if we use the language of the risk needs responsivity model, which is sort of embedded in the way that corrections responds to people who offend here in Australia, trauma may be regarded as a factor that directly influences dynamic criminogenic needs. Trauma influences responsivity, specifically a person's capacity and ability to focus and engage, which may be referred to under the R&R model as poor engagement, but that's definitely not therapeutic or trauma-informed language, but it should be familiar, I guess, to people who work in corrections. Using the R&R model, Katherine McLachlan and colleagues in 2021 undertook a narrative literature review exploring the association between trauma and offending behaviour. They found that trauma contributes to the central 8 needs: substance abuse, relationship problems, poor engagement with education or employment, poor engagement with leisure and recreational activities, antisocial behaviour, including criminal behaviour, antisocial personality, antisocial attitudes, values and beliefs, and antisocial friends and family. So trauma is closely associated with criminogenic needs. And so addressing the manifestations or the symptoms of trauma may help reduce recidivism, but we do need to do more work in this area. So I guess the takeaway here at this stage in the presentation is there is a general association between trauma and trauma can be a risk factor for crime, but trauma does not cause crime. So we don't have the evidence at this stage to say trauma is causative of crime, but there's definitely a correlation between the two. Okay, so what do we mean when we talk about trauma-informed practice? Trauma-informed care and practice was developed 20 years ago and is emerging as an important way of working for police, in corrections, in courts, and in broader contexts such as health and education services. However, few academics have examined whether trauma-informed practices exist across criminal justice agencies or in sentencing. So this concept of trauma-informed emerged in 2001 in the works of Maxine Harris and Roger Fallett. Trauma-informed practice is not designed to treat trauma, so that's more often referred to as trauma-focused practice. But trauma-informed practice requires service providers at all organisational levels understand the potentially traumatic effects of adversity on an individual's ability to function and interact with the world, and promote service environments conducive to recovery and that avoid further re-traumatisation. More recently, trauma-informed practice has been refined, particularly by mental health and substance abuse professionals. So there's been a substantial increase in trauma-informed publications across various disciplines over the last decade. Trauma-informed practice extends across health and therapeutic services, education, disability, community services. I'll talk a little bit later in the presentation about trauma-informed correctional care, which is being applied in mainstream prisons. But there's also concepts of trauma-informed lawyering and trauma-informed youth justice as well, which are emerging. And so the key notes that you can see here on the slide are that trauma-informed practice recognises the relevance and prevalence of trauma and uses that knowledge to inform practice responses and prevent further trauma. And a key message that I want to sort of come through the presentation, and I'll reiterate again, is that trauma-informed practice is not just for people with trauma, it's for everybody. Okay, so is it enough to just be sweet, nice, and kind? So before I tell this story, I'm just going to explain the photo here on the slide. So this is a photo of my daughter and my father that was taken in March this year. So in January this year, my father had a cardiac arrest. So you can see he's still alive, so we're good. He was staying in his on-site caravan alone in a beachside caravan park about an hour's drive from home in Adelaide here in South Australia. That morning he drove into town to buy a paper and he collapsed on the footpath. Luckily, it happened across the road from a medical centre, meaning he got immediate medical attention. He was revived, taken by ambulance to the local hospital, and then airlifted by helicopter to Adelaide, where we live. And I know all of that because 3.5 hours after the cardiac arrest, I spoke to the local police officer. He'd spent a couple of hours identifying who my mum was, wondering where she was, and identifying her phone number through family medical records. He called her, she'd asked him to call me, and he explained to me the situation. So over the next couple of days, Senior Constable First Class Andrew Francis rang me. He asked whether we'd like him to turn off the caravan power, remove and dispose of the food in the fridge. He took possession of Dad's car and put it in a secure parking lot until we could arrange to collect it because Dad was now back in Adelaide with us. He also located and secured Dad's mobile phone and laptop for us. So this was all happening while Dad was in ICU in a coma. He kept the local community members informed of Dad's progress so that they were aware that their actions had literally saved his life. And so what's the point of this story? Aren't we talking about being sweet, nice, and kind here? Aside from garnering your sympathy early in the presentation in case, we crash and burn later on, the point is that Senior Constable Francis's actions could well be regarded as trauma-informed policing. In many ways, they reflect a trauma-informed response. He was patient and he was compassionate. He built trust and made me feel safer by answering all of my questions, sometimes that I asked more than once. And he offered choices and solutions and was very flexible. He gave us control over the small things when a lot of things were outside of our control. We weren't really sure, how Dad was going to go, what the extent of the damage was from the cardiac arrest at that stage. However, while Senior Constable Francis's actions contain many elements of a trauma-informed policing response, I'm pretty confident as a man with 40 years policing experience, he's probably never heard of trauma-informed practice. Fundamentally, he was just being a good cop and being a decent person. In fact, trauma-informed practice is not simply about being sweet, nice, and kind. It actually requires a framework. So here's a framework for trauma-informed practice. So this is taken from SAMHSA's 2014 explanation around trauma-informed practice and care. And they put forward that to be trauma-informed, a service or a sector must first of all realise the impact and relevance of trauma and the potential impacts of adversity. Secondly, recognise signs of trauma in an individual and how it might manifest for that individual. Thirdly, respond appropriately to the individual's unique trauma. And we'll talk in a minute about some of those trauma-informed principles of practice that characterise a trauma-informed response. And finally, act to resist re-traumatisation by avoiding insensitive or inappropriate responses when providing services. So this approach I refer to through this presentation as the 4 Rs: realise, recognise, respond, and resist. And a trauma-informed response, so the third R there, requires the application of specific principles of practice. So let's unpack those a little bit further. Okay, so Blue Knot, which is a not-for-profit organisation in Australia that supports adult survivors of child sexual abuse, refer to 5 foundational principles of trauma-informed care: safety, trustworthiness, choice, collaboration, and empowerment. And you can see on the slide here, some of these have been put together. So SAMHSA, they talk about empowerment, voice, and choice as one principle of practice. And they also add in cultural, historical, and gender issues. But if we unpack each of these in terms of what they actually mean in terms of practice for criminal justice agencies, safety refers to effective and consistent physical, but also emotional safety. Trustworthiness refers to establishing mutually understood, clear and consistent expectations and boundaries for workers and service users. And so sort of building trust between the worker, whether they're a police officer, a prison officer, a community corrections officer, a judge, a lawyer, and their client or the individual who is engaging in the justice system. Choice involves giving control over users' service preferences through information, options, and an awareness of their rights and responsibilities. Collaboration involves service users in the planning and shared decision-making around activities and settings relating to service provision. And empowerment aims to promote the service user's skills through a strengths-based approach. And as I said, SAMHSA added in the cultural, historical, and gender issues as a principle of itself, rather than embedding them in other principles such as empowerment. So how's this model of trauma-informed practice relevant to the criminal justice system? Before we talk a little bit more about that, I just want to highlight that I've put safety at the top intentionally to really flag that even though all the principles of practice are fairly equally weighted, safety is kind of at the core of everything that agencies should be doing when working with individuals. If you act in a way that promotes safety for that individual and perceived safety, then fundamentally most of these other elements will come out in the way that you're responding and working with that person. So building on that idea of safety, the concept of resisting re-traumatisation is the most important of the SAMHSA's 4 Rs: realising, recognising, responding, and resisting. For if the criminal justice system resists re-traumatisation, they're likely to achieve all of those other concepts because practitioners are likely, first of all, to realise how trauma is relevant in their work, that first R, recognise how trauma may impact someone's criminal behaviour or the different ways victims of crime may present, or when a co-worker appears to be overwhelmed with work, that second R. If criminal justice system agents actively seek to resist re-traumatisation in the work, they're likely to be responding in a way that promotes those principles of practice. So that's safety, choice, trust, empowerment, recognising the relevance of culture and gender, those kinds of things. So I've already given you an example of policing that did demonstrate the different principles of practice in practice. But what I want to do now is use an example from policing that demonstrates when police did not resist re-traumatisation. And then we'll talk through the importance of why this principle is actually core at as an element of good practice. So 15 years ago, I interviewed victims of sexual assault about their experiences reporting to South Australia Police. And one woman and her experience is unforgettable, and I called her Charlotte. Charlotte was 16 years old. She'd never had sex. She was asleep in her bedroom when someone broke into the house, restrained her and sexually assaulted her. Her father interrupted the assault, the perpetrator escaped, and the police were called. And Charlotte said, a policewoman arrived and she said, look, we need to give you a description of what he looks like straight away so we can try and find him if we're able. And so I started giving this description, and while he was in my room, I deliberately tried to remember everything I possibly could about him. And this policewoman said, you remember so much, it's as if you've made the story up. So that was the first thing she said to me, and I felt really, really bad. I felt wrong. She actually made me feel really alone in saying that. So keeping in mind, Charlotte was 16, and her dad was a witness to the assault, and the police officer said that to her. Charlotte was required to give a statement the same night she'd been assaulted after she'd undergone a forensic medical. She was not advised that she could have a support person present, nor were counsellors contacted. She said, a policewoman gave me a cup of coffee and she asked me if I'd like a cigarette, and I said no. And she said, well, often women like to have a cigarette after they've been raped. The same night, a policewoman said to Charlotte, now this has happened to you, you're going to probably want to have counselling, or they'll offer counselling to you. And she said, be really wary of it. There are groups around, but they're feminist groups. And I didn't know much about feminists, and she said, well, most of them are lesbians. And she said, they'll try and turn you into a lesbian. And I didn't even know what a lesbian was. I was going through puberty, and I was just too self-conscious about sexuality and sex to even, have thought about any of this. And so that's actually why I was really dead set against counselling at the time. So clearly nothing about that experience was okay. And as a result of her experience, both as a crime victim and with the police, her life trajectory completely changed. She moved away from South Australia and, like many victims of crime, was re-victimised many years later. So this is not the police achieving its goal of community protection. It's the very opposite. This example demonstrates why it's incredibly important that police respond in a way that always resists re-traumatisation. So let's finish Charlotte's story. She said, I'd ring the detectives and ask them to inform me how they were going with this, and they said they had leave and they were hunting down leads, and it felt like a comedy act. I felt that they weren't giving me any information. I didn't feel that they put my mind at ease in any way, so I left. I rang them from interstate over the years a few times and said, did you ever find more information? Have there been any similar cases anywhere else? They said no, and they said it was unusual for me to ring. I mean, I'd ring maybe once every 6 months or so, a couple of times within a 2-month period. And they said, none of the other girls have rung. Why are you ringing? And then they said, let it lie, let it go. So that case study I raised recently in February at a conference around trauma-informed policing. And a police officer came up to me afterwards and had some fair points that he made, but fundamentally he was trying to say, well, victims of crime don't fully understand the pressure that police are under and the work environment that police deal with. So it's not necessarily that they were trying to offer a poor experience. It's just that through the lens or the eyes of the victim, it felt like a poor experience. And so I reflected on what he said. And I think, my husband used to be in the job. I do understand police officers often work shifts and they're not always available or able to visit or call a victim of crime promptly. You don't want them to ring at 3 a.m. because that happens to be the shift when they're working the case. And sometimes victims may not understand that operational demands may prevent timely and thoughtful police responses. That is also true. However, and this is the point that really I think needed to be made in response to that police officer's comments, police officers must put themselves in a victim's position and consider how their responses, delays, comments, or actions might be misunderstood or misinterpreted. Police should consider how a throwaway comment might potentially change someone's life. So suppose that in all cases, all police officers strive to act in a way that promotes safety, trust, and choice for victims of crime. You can see how the 4 R's coexist. You can't resist re-traumatisation without a trauma-informed response. Such responses will likely leave a positive legacy that does not re-traumatise. So if police are promoting safety, they're promoting trust, they're communicating clearly, they're giving victims of crime choices about how they receive information or updates from police, they're likely to reduce that chance of re-traumatisation. Police should always reassure victims of crime that they're respected and not blamed, and that their concerns have been heard. Police should answer victims' questions and offer time and space to process what's happened. Such responses could help minimise the trauma caused by the criminal justice system. Okay, so let's get to the core of the presentation, which is, isn't trauma-informed criminal justice an oxymoron? Trauma-informed practice and care in the criminal justice system is in its infancy. Trauma-informed policing tends to focus on victim services, particularly for sexual violence offences. Existing trauma-informed correctional care focuses on women in custody and children in detention, but not men in custody. Many of the practices claimed to be trauma-informed are in fact just professional and appropriate services. The criminal justice system, as I said, is inherently traumatic. But there's no excuse not to try constantly to improve the system. It's that old adage, is imprisonment punishment of itself, or is imprisonment a vehicle for more suffering? Trauma-informed criminal justice can help to achieve the overall purpose of the criminal justice system, to keep communities safe through a reduction in crime. Most people who are incarcerated will be released back into the community at some point in time. And we know currently contact with the criminal justice system, so being in prison, for example, is criminogenic. It causes further crime. So what if we aimed instead to address that? So you can see 3 key questions here on the slide. That relate to, how can we truly be trauma-informed across the different justice agencies? How can we arrest someone safely? How can we resist re-traumatisation in prisons? And how do we collaborate in sentencing? So I'm going to give you one example for each of those points, which I think demonstrates that it is possible. So in terms of how we can arrest someone safely, there's an example of trauma-informed policing from Norway, which focuses on situations where police arrest and deport children who lack legal residency. Police are guided by principles of safety, understanding, predictability, and involvement, which broadly reflects the trauma-informed principles of collaboration, choice, and empowerment. Arguably, and no question, the process of being deported is inherently traumatic. But the strategy that they employ aims to reduce re-traumatisation and promote procedural justice rather than empower the children or offer any sense of choice in the outcome. So there's some real pragmatic balance there around arresting someone safely in a way that is not overly traumatic, given the inherent traumatic nature of the process itself. It's basically not trying to add extra layers of trauma to the situation. How can we resist re-traumatisation in prisons? Well, I guess my point here, and we will talk a little bit more about trauma-informed correctional care in the next slide, is that while prisons may incapacitate people in the short term, most people will be released into the community. So it's not so much how we can, but that we must. We absolutely have to reduce re-traumatisation in prisons. And thirdly, how do we collaborate in sentencing? So one of the strongest examples I've seen of this in my PhD research was a judge who, whenever people got a community-based sanction, the judge would have conversations with them about whether they were able to abide by the conditions and whether the conditions were reasonable. And in one case, a woman was given a community-based sanction that she was supposed to complete in South Australia. And she had a conversation with the judge about the fact that she had a job offer going in Western Australia. So could she have the conditions amended so she didn't have to stay in South Australia while she was under supervision, that it was transferred to the Western Australian Corrections to manage her instead. So that's an example of collaboration in sentencing. Okay, so I've already talked a little bit about trauma-informed policing and where it has and hasn't occurred, but let's move on now to trauma-informed correctional care. Trauma-informed correctional care has emerged as a therapeutic approach in prisons and in the community. It can be considered to be a behaviour management strategy and a safety strategy for correctional staff and for clients. At a minimum, trauma-informed correctional care requires that employees recognise that engagement with correctional services need not be fundamentally traumatic. Trauma-informed correctional care requires that staff apply trauma-informed principles of practice to their daily work. Programs and interventions delivered by or on behalf of corrections are designed explicitly to be trauma-informed, particularly for women and children who have offended, while, quote, male correctional populations are among the last frontier for trauma-informed care implementation. In Australia, the guiding principles for corrections endorse continuous improvement, staff education, and respectful searches, and emphasise that individual prisoners or offenders, depending on where they are, I guess, community, they refer to them as offenders, are managed in and supervised in a manner that responds to the particular risks and needs, including the impacts of victimisation and trauma. So arguably, trauma-informed correctional care is perceived as a good practice and there's some top-down directions for it to happen. But is it current practice? I'm actually going to use a couple of New Zealand examples to show where it can be regarded as current practice. Okay, so while I was visiting Hamilton recently, I was lucky enough to visit Spring Hill Correctional Facility and learn a little bit more there about the remandee experience. Obviously, the original physical design and operating philosophy back when Spring Hill Correctional Facility was built were arguably trauma-informed. But after the 2013 riots, when the environment was hardened up significantly, there was nothing nice about Spring Hill Correctional Facility when I visited. So I went into one of those little concrete wombs that you can see there on the slide, where the yard has been concreted over and there's significant fencing within the secure area for the people in the prison there. And these are people who are on remand, so they haven't been found guilty of the offences for which they've been most recently charged. But arguably this correctional facility does not reflect trauma-informed principles of collaboration, peer support, safety, trust, empowerment, voice, choice, or cultural issues. However, I was also lucky to visit another prison while I was in New Zealand, and this was really a great example for Australia to learn from. Now, I need to say here, we have a suburb in South Australia called Waikerie, so I'm going to try not to say it with an Australian accent. Waikeria remand unit, hopefully I said that okay, Tatara. We went and visited and had a chat to the Runanga there, so 4 men who are on remand in this prison. And I should say, I do understand that this is a low security environment compared with Spring Hill, but fundamentally they're the same population. These men understand and have experienced Spring Hill as well. They know how lucky they are to be in Tatara rather than Spring Hill. So it was a great conversation that we had among the Runanga. So we had 2 Māori men and 2 non-Māori men that we spoke with. And we also spoke with a couple of staff in there as well. And there was clear respect between the staff and the residents in Tatara. So there was clear collaboration in terms of how they managed the area, how they kept people safe, how they made sure that new arrivals understood the processes and what was expected of them. There was obvious peer support. I can't remember the names because I couldn't take notes while I was in there, but one of the Māori men that we spoke with was fantastic at demonstrating how he helped people settle in, how he helped manage minor disagreements without the need for staff to be involved. And there was definitely safety and trust between the staff and the Runanga to talk about how to make it work really well and keep it a safe place for everybody within the system. There was clear empowerment of people who were residing in Tatara. They had voice and choice in how things happened, opportunities for work, opportunities for gaining qualifications, and there was clear respect for cultural issues in there as well. So it was a super impressive visit, and I was really interested, and we got a chance to have a chat to the men afterwards about their experiences. Will the new build be trauma-informed? I guess that's probably a whole other presentation, and my concerns are possibly not. But we will see in terms of the operating philosophy and a whole lot of other factors once it's actually live. Okay, so now if we move to sentencing. So as you would understand, sentencing involves determining an appropriate sanction in response to proven criminal behaviour based on the law, the context and the surrounding circumstances of the offence. So we've revisited again here the SAMHSA 2014 model of trauma-informed practice, the 4 Rs that I talked about before, but this time they're applied to defendants in the process of sentencing. So the first R is where the judge realises the impact and relevance of trauma on a defendant or within a defendant's life. Secondly, the judge recognises signs of trauma and associations between trauma or adversity, trauma and criminal behaviour. And courts can recognise the relevance of trauma as a sentencing factor to give weight to the sentencing calculus. So trauma may be perceived as an aggravating or a mitigating sentencing factor. So a trauma-informed sentencing process isn't necessarily always in the best interests of the defendant in terms of a smaller sanction, but it's certainly a more informed way of the judge taking into consideration a lot more of the contextual factors around why the offence has occurred, some of the elements of the offence, before reaching and responding in this case and reaching a sanction. So responding in a trauma-informed way talks about both the process, so the court process, the court experience, the judge explaining things in a way that is at the appropriate level of comprehension for the people who are involved, but also sanction as well, and then resisting re-traumatisation through the process itself. Arguably, a trauma-informed sentencing process can be applied to victims or to defendants. So this case is quite infamous in Australia. In 2021, Brittany Higgins, a young political staffer, alleged to the media 2 years earlier that she was raped by a colleague, Bruce Lerman, who you can see on the screen here. The case went, and that was inside Parliament House in Canberra. The case went to trial, eventually ending in a mistrial and a statement from the DPP that they'd not pursue the matter further due to the impact on Higgins' health. And then Bruce Lerman initiated a defamation trial. So we know trauma-informed responses to victims of crime help to reduce re-victimisation, uphold victims' legal and human rights, and can result in better criminal justice outcomes. For some victims of crime, experiences with the criminal justice system may be more traumatic than the crime itself. Often criminal justice professionals lack the knowledge that trauma may manifest in different ways for different people, and that memory and recall can be impacted by trauma. And myths about how real victims respond to trauma can negatively influence the way the criminal justice professionals respond to victims of crime. So in this case, the federal court, so Justice Lee, found on the balance of probabilities, obviously a lower threshold than the criminal case, that Bruce Lerman did rape Brittany Higgins in Parliament House in 2019. And you can see here on the slide a quote from Brittany Higgins after the judgment was released. It's like odd 300 pages, very entertaining and definitely worth reading if you're interested. Brittany Higgins said, "Thanks to Justice Lee for his trauma-informed approach, recognising that reactions to assault can vary widely. In doing so, I hope he's set a new precedent for how courts consider the testimonies of victim survivors of sexual assault." So Justice Lee delivered the judgment in Mr. Lerman's defamation case against Network 10 and journalist Lisa Wilkinson, finding the pair had sex in the office of Senator Linda Reynolds, and Ms. Higgins did not consent, and Mr. Lerman was indifferent to whether she had consented. Okay, so now if we talk about trauma-informed sentencing for defendants, in my PhD, I examined 448 sentencing remarks and found very few defendants experienced trauma-informed sentencing. And when I talked about trauma-informed sentencing, again, I used that 4Rs model: realising, recognising, responding, and resisting. So in about half the sentencing remarks, defendant trauma was acknowledged by judges to be present. So judges realised adversity, including adverse childhood experiences, as well as adult onset adversity. And in fact, they preferred adult onset adversity. They liked it to be sort of timely to the offending behaviour. Judges recognised a trauma-crime relationship existed, most often when the trauma was recent, when adversity had led to drug and alcohol abuse, and where the defendant had been diagnosed with a DSM mental health diagnosis. Some sentencing judges explicitly recognised that trauma explained criminal behaviour, but regarded trauma as no excuse for the crime. And you can see here on the slide how I define the elements of a trauma-informed response. So safety was demonstrated where the judges referred to the defendants directly by name, where the judge acknowledged and basically spoke directly to the defendant. So there were cases where the judge might refer to the victim by name, but the defendant as the defendant or the accused throughout the process, even though they were clearly in the courtroom at the time. So that kind of dehumanization, that language. Trustworthiness and transparency were demonstrated where judges explained an element of the sentencing process to the defendant. So they made sure that the defendant was following the process and understood how they'd reached their decision. Empowerment and safety occurred when judges asked the defendant whether they understood the sentencing sanction. And choice, collaboration, and empowerment were demonstrated where judges asked the defendant whether they that is not true. Choice, collaboration, and empowerment were demonstrated when the judge basically had a conversation, as I said before, when they were community-based sanctions to see if the defendant understood what was happening and that they were willing to sign the bond or the agreement to say, yes, they would actually abide by those conditions. So when judges actively decided to impose a trauma-informed sanction, the most often one that they would impose was a short non-parole period with a longer period of supervision in the community. And you can see here her quote, which is fairly sort of similar to these examples, fairly common across those. So in this case, the judge said, I consider a short prison sentence is justified. It would be much shorter than would normally be the case because of your chaotic and unstable childhood, disrupted education, and all the mental health aspects which your lawyer has gone through, which I do not need to repeat. So you can see often the judges would use adversity rather than the impact of adversity to sort of represent trauma. They would infer from those life experiences that the person had their well-being and functioning impacted upon. But the downside to these short sentences, and all the literature tells us this, is that they're just long enough for the person to lose their home, which is quite significant at the moment. We have a shortage of public housing and affordable housing in South Australia. They'll lose their jobs. They might lose their children to child protection systems. They'll lose their family and friends, maybe their partner. So all of these protective factors get lost through being imposed a short prison sentence where they're removed from the community. There were some cases where judges sought to resist re-traumatisation where exceptional circumstances were identified. So that wasn't necessarily if they were a parent, but it was if they were a parent of a child who had special needs, for example, and a sole parent. So we know too that since the late 20th century, smart justice initiatives have emerged, including restorative justice, problem-solving courts, neighbourhood justice centres, and therapeutic jurisprudence. Smart justice approaches are designed to be cost-effective, take a more person-centric approach, and address the underlying causes of crime and reduce recidivism and future offending. And I would argue that trauma-informed sentencing aims to achieve all of these sort of key targets. And there's definitely a parallel between trauma-informed sentencing and therapeutic jurisprudence. The main difference being therapeutic jurisprudence is all about the law, and it focuses on the law and how the law can be as sort of as therapeutic as possible. Trauma-informed sentencing focuses more on the individual. So what do we know about that person and how can we respond to that person through the legal processes in a way that reduces trauma for them? So I think a key concept in the work that I've done around trauma-informed criminal justice has been compassion being at the centre of those practices. And compassion centres around a collective and empathic understanding of human suffering. It's an intentional response aimed at relieving the suffering of others. And Anthony Hopkins and colleagues focus on humanising the people who offend, quote, to understand the individual and systematic causes of their criminality. So I want to draw from one more example here today and consider the humanity of someone who has offended. And we're going to call him Max. Max is one of the defendants from my trauma-informed sentencing research, which was part of my PhD, and he was convicted of drug trafficking in his early 40s. His story illustrates why people who offend should always be treated with compassion, because you don't necessarily know the depths of adversity that some people have experienced, which increases their risk of offending and reoffending. So I'm going to use an excerpt from the sentencing remarks to explain to you Max's life. It's reasonably detailed, so stick with me. Your mother was 16 years of age when she gave birth to you. Unfortunately, at that time, she was consuming drugs and was charged and sentenced for drug trafficking not long after your birth. Your mother only returned to you when you're about 6 months old. You've never known your father. Your mother began a relationship when you were about 4 years of age, and this relationship was marred with alcohol abuse and violence against your mother. You recall your childhood as not being particularly happy or stable. You were often left to fend for yourself. You remember occasions when you were left seemingly forgotten by your carers in the bush, at parks or at the beach, and at some time for days. These experiences fostered a sense of abandonment that has followed you through your life. Your younger brother was born when you were 6 years of age, and this was a particularly difficult time for you as you remember the violence within your household escalating. You remember your mother being covered in blood on several occasions. You also remember how you were the victim of severe beatings by your mother's partner. This was done with a stick that had nails attached to it. While your family was living interstate, you were beaten so severely that your kneecap was broken and you spent 2 months in hospital. You recall this time in hospital feeling quite like you were on holiday as you were treated well, fed well, and there was no violence. Not long after returning home from hospital, you made friends with a person who molested you. Your stepfather began molesting you from the age of 9 to 13 years. While a lot of this was happening in your life, you managed to thrive at school. You were well liked by other students and teachers and were always at or near the top of the class. However, you left school at 14 years and began working in an effort to support your mother financially. When you were aged 15, your brother's father reappeared and took your brother away to live with him, and that devastated you and your mother. Aged around 28 years, you were the victim of a home invasion. You were with a friend at the time, and while you managed to escape over a balcony, your friend was severely beaten, and this ended your friendship, and you've carried the burden of guilt ever since. At that time, you began to use methamphetamines to cope with the trauma of the home invasion and your depression. By the time the court case ended, you were heavily addicted to methamphetamines. You were sentenced for trafficking in methamphetamines. During this incarceration, your mother passed away from lung cancer. Your brother moved to join you in Adelaide. He had a severe drug problem. You also lost your brother to suicide in 2016. He was unable to cope with the drug debts he had accumulated. A gang that alleged your brother owed them $100,000 threatened you and made you take responsibility for your brother's debts. You've submitted it was for this reason that you turned to selling drugs. You knew you should have gone to the police, but from your past experience as a Crown witness, it was too traumatic for you. So we can hear from that story, from those sentencing remarks, that Max experienced extensive adversity in childhood, parental substance abuse, absent father, domestic abuse, childhood physical and sexual abuse, and also in adulthood, a physical assault, death of a parent, and suicide of a brother. These life experiences help contextualise why Max has offended and the triggers or life events that increase his risk of using illicit drugs and committing offences. It makes sense to me that if we as a society and as the criminal justice system want to support Max to desist from his offending, we must realise and recognise him as a human being and the significance of the past adversity that has led to his trauma and criminality. It seems obvious to me that taking a tough-on-crime approach and focusing on punishment and specific deterrence is just compounding the trauma. Focusing on Max as a citizen allows the justice system to formulate a plan for his rehabilitation and reintegration tailored to his specific risks and criminogenic needs. And in this case, the judge concluded, I'm precluded from granting you a home detention order as your offending is categorised as serious organised crime. I have the discretion to grant such an order if I were satisfied that exceptional circumstances exist, but I am not so satisfied, and I decline to do so. So the concept of exceptional circumstances relates to special or uncommon mitigating factors, including where the person's personal circumstances are so exceptional as to outweigh the paramount consideration of protecting the safety of the community, whether as individuals or in general, and personal and general deterrence. And personally, I wonder what the threshold is for an exceptional life if Max's is not it. So you can see here the decision represents 2 of the 4 R's. The judge absolutely realised trauma was present and he recognised that the offending trauma association existed. But there was no trauma-informed response in terms of process or outcome. He did not resist re-traumatisation for Max. So a key message that I want you to take away is that trauma-informed practice is universal. We know currently universal trauma-informed criminal justice doesn't exist for everybody yet. And ideally, trauma-informed criminal justice is not just for real victims, and it's not just for people with pre-existing trauma. It's an approach that can benefit everybody. Trauma-informed criminal justice should be universal and systematic, such that trauma-informed approaches are the responsibility of individual workers as well as justice organisations. We know that most examples of trauma-informed criminal justice focus on small elements of a trauma-informed approach, such as acknowledging and applying victims' rights. But true trauma-informed responses offer compassion not only to victims of crime, but to people who have offended. And they're also designed to support workers too. So one of the areas that I'm working on now with Andrew Day from the University of Melbourne focuses on vicarious trauma. Working in the criminal justice system can be stressful due to both direct adverse experiences and exposure to the distress and trauma of others. Research indicates police officers, correctional service workers, and legal practitioners are often diagnosed as having high levels of anxiety, depression, and PTSD, higher than the general population, as well as alcohol use disorders. However, what we're also finding is that work-related distress in the criminal justice sector is not often caused by critical incidents so much or the nature of the job per se, but by an employer or leadership team that's perceived as unsupportive or uncaring. A trauma-informed response can help promote a healthy workplace for workers, clients, and others. And a trauma-informed organisational response does not require that everybody has experienced trauma for it to be helpful for the workers in the workforce. So I'm powering through because I'm conscious we're running out of time. Trauma-informed criminal justice is good practice. It's more than just being sweet, nice, and kind. It's about being smart, being cost-effective, being person-centred, and being evidence-based. It's partially reflected in current practice, but ideally, trauma-informed criminal justice is structured. It's a conscious decision to work in a way that resists traumatising and re-traumatising anyone who has contact with the criminal justice system. While we have an adversarial criminal justice system, I argue that trauma-informed practice is not an oxymoron, but necessary to ensure we don't drift into further punitive populism, driving higher prison and prisoner numbers, resulting in greater levels of recidivism and a clear graduate pathway for multi-generations within a family who are already facing significant disadvantage and trauma. We know the current ways of working are not working, and so what is there to lose by bringing greater compassion, care and safety to the criminal justice system? So do you want to know more? Today has been a taster. I haven't really touched on culturally safe practices today, although I do discuss those in my book. And the publishers are telling me the book should be out in June this year, so we'll see how that goes. Is the book any good? Well, we have a quote here from the lovely Devon from your university that hopefully will compel you to think that, you know, in addition to the conversation today, that it's worth your while to give greater regard to trauma-informed criminal justice and trauma-informed practices. And so thank you very much for your time today. Here we have my email, my Twitter, which I don't use that much now that it's become X, and a link to the Magnolia Project and my personal website as well. So thank you very much for your time.